Good morning, everyone, and thank you for joining us. Bon matin, et merci d'être avec nous ce matin. Mon nom est Tim McSorley. My name is Tim McSorley. I'm the National Coordinator of the International Civil Liberties Monitoring Group, and I'll be moderating today's press conference. Mon nom est Tim McSorley, et je suis le coordonnateur national de la Coalition pour la surveillance internationale des libertés civiles, et je serai le modérateur pour cette conférence de presse ce matin. Tandis que la conférence déroulera en anglais, s'il vous plaît, n'hésitez pas de poser vos questions en français et nous répondrons en français aussi. As we start, I'd like to acknowledge that I am joining the call from Ottawa on the unceded territory of the Algonquin Anishinaabe people. We pay respect to the Algonquin people who are the original guardians of this territory and thank them for their stewardship of this land. At today's press conference, we'll hear from 4 speakers, who I will introduce shortly, followed by a question period. I'd also like to mention a quick correction to the press release that was sent out yesterday. It erroneously said that the French Court of Appeal decision to send Hassan Diab to trial was made in 2019, when in fact it was in 2021. We're holding today's press conference to once again denounce the deep injustice that Hassan Diab has faced over the past 15 years at the hands of both the French and Canadian governments. As today's speakers will explain, it is unconscionable that the Canadian government continues to refuse to commit to no new extradition of Hassan Diab to France. While Prime Minister Trudeau and his government have refused to take a position, thousands of Canadians and other supporters have not. Today at noon, the Hassan Diab Support Committee will be hand-delivering a petition with more than 10,000 signatures to the Prime Minister's office at 80 Wellington Street, demanding that he commit to no new extradition of Hassan Diab. We hope that Prime Minister Trudeau and newly appointed Minister of Justice, Arif Virani, take this opportunity to do the only just thing and commit to ending this miscarriage of justice. As I mentioned, we have 4 speakers today. First, we'll hear from Hassan Diab himself. Following Dr. Diab, we'll hear from Alex Neve. Mr. Neve is an international human rights lawyer with over 30 years' experience as a leader, researcher, advocate, and educator. He is currently a senior fellow in the Graduate School of Public and International Affairs at the University of Ottawa. Next, we'll hear from Bernie Farber. Mr. Farber is a human rights advocate, writer, and speaker. He is the founding chair of the Canadian Anti-Hate Network and past CEO of the Canadian Jewish Congress. Following Mr. Farber, we'll hear from Robert Currie, who is a distinguished research professor at the CSILC School of Law at Dalhousie University and a leading expert on Canadian extradition law. Also joining us today are Roger Clark and Maeve McMahon, who are both members of the Hassan Diab Support Committee and who are available to answer questions during the question period. Without further ado, I'll hand things over to Hassan Diab.
Oh, good morning, everyone. Thank you for coming today. Let me be clear from the outset. In January 2018, 2 French investigative judges found, after a lengthy investigation, no credible evidence to send me for trial. They dropped all the charges against me and ordered my immediate and unconditional release after I had spent 38 months in Europe's largest jail near Paris, most of the time in solitary confinement. I immediately returned to my home and family in Canada. 5 years later, with no new evidence whatsoever, and with 5 freshly appointed judges who were not familiar with this complex case, like the 2 investigative judges, the Special Court of Assize conducted a trial in absentia. Yes, in absentia. That does not meet basic international standards of justice. The bar for conviction is extremely low, and so-called intelligence plays the major, if not the only, role in the verdict. Imagine a court that provides no records or transcripts of what takes place inside, or imagine a court that ignores all exonerating evidence, university record, documents, alibis, fingerprints, and palm prints that do not match, and instead relies on discredited and unfounded allegations. The outcome will surprise no one. I was wrongfully convicted in a highly politicized trial based on unsourced intelligence and old discredited material. It's a case of judicial versus political. The judges said, no, I shouldn't be sent to trial. The political side said he should be convicted. My ordeal has been going on for 15 years and counting. The situation is back to square one, just when I thought the dark chapters had closed. Canadians showed great support and were dismayed by the wrongful accusation, extradition, and conviction. I thought Prime Minister Trudeau would put an end to my ordeal in 2018. That's in June 2018. I thought he was ready to follow through on sincere feelings for me and my family when he said that what happened to me never should have happened, and more importantly, shouldn't happen again. Never should happen again. I felt I could finally sleep well after that statement and not have my children feel my anxiety at the thought of my potential disappearance from their lives again. My young son sees me in photos when his big sister was born and wonders why there are no such photos from when he was born. I cannot tell him I was in prison 5,000 miles away at that time. I'm not sure what to tell my children if Prime Minister Trudeau does not honor his words from 2018. I'm concerned about what to tell my children if I'm forced to go through another round of wrongful accusation, extradition hearings, and so on. My daughter is starting to feel the pain of a possible separation. She remembers that she practiced her first scribblings in a letter she wrote to Minister Chrystia Freeland at the time when I was in prison in France, asking her to help bring me back to Canada. Minister Freeland wrote back to my daughter, promising to do her best to bring me home. I'm not sure how my daughter will feel if she's let down. The silence of the Canadian government has a very powerful echo. It keeps me wondering what's next. Is it another storm or genuine peace? For how long does the government want me to live in a state of limbo? I started wondering if the next person or car coming around the corner of my home will mean the beginning of another round of torture that I have experienced for so many years. The decision makers will not make the case go away simply by dropping our requests and not speaking out. No, the case will not evaporate by itself. The question remains, for how long is this government willing to remain silent? The only way to solve this problem is for Prime Minister Trudeau to translate his words into action. Otherwise, I will continue to feel like an inmate on death row. Lastly, I want to thank all my supporters in Canada and elsewhere who signed the petition, and I invite everyone to sign the petition by simply going to our website, justiceforhassandiab.org. I'm deeply grateful and heartened by your support. Thank you.
Thank you very much, Hassan. And now we'll go to Alex Neve.
How many times have we come forward to say that it must end here? The injustice, the human rights violations, the Kafkaesque absurdity of Hassan Diab's journey through Canada's extradition process, that it all must end here. And what a stunning indictment of Canada's justice system that this has instead continued for 15 years. And that we are once again here today After years of concerns about grave human rights violations, including arbitrary arrest, unlawful detention, and torture and ill treatment, and still it has yet to come to an end. Some may assume that the fact that there has now been a French court judgment convicting and sentencing Dr. Diab for the 1980 Rue Copernic synagogue bombing does bring it to an end. To the contrary, it only deepens the injustice and extends this dystopian affair. A blatantly unfair trial has resulted in a blatantly unfair, wrongful verdict. And Dr. Diab remains trapped in a labyrinth from which it often seems there is no exit. But there is an exit, and that is why we have come together today. Over 10,000 Canadians are calling on Prime Minister Trudeau to make it clear to France that Canada will not participate in this charade any longer. We do, of course, agree, all of us, unconditionally, that there should and must be justice for the terrible terrorist attack that claimed 4 lives and injured so many others in Paris more than 4 decades ago. Justice, however, does not in any way lie in scapegoating an innocent man and flouting international human rights obligations. Justice is served by adhering scrupulously to the rule of law, fair process, and a full embrace of human rights. And that needs to start now. As we've just heard, Dr. Diab does not even know if French authorities have formally sought his extradition. He has no right to know that unless the Canadian government decides to formally launch an extradition hearing. And until then, he and his family are instead left in agonizing limbo for weeks, for months, indefinitely, never sure when a knock may come at their door. C'est clair et c'est attendu depuis longtemps. Le Premier ministre Trudeau et son nouveau ministre de la Justice et procureur général Arif Virani doivent envoyer un message clair au gouvernement français. L'injustice prend fin maintenant. Une seconde extradition d'Hassan Diab n'aura pas lieu. It's an opportune time to send that clear message. Thousands of Canadians have asked the Prime Minister to do so, and yesterday he appointed a new Minister of Justice who has the power and authority to stop this injustice in its tracks. Prime Minister Trudeau was unequivocal 5 years ago in saying that what happened to Dr. Diab should not have happened and should not happen again. Now is the time to show that those were not just words, they carry meaning. We all look to the Prime Minister and now also to Minister Virani to make it unconditionally clear to the French government, to Dr. Diab, and to all Canadians that this extradition, whether it has been formally initiated or not, will not proceed. Thank you.
Thank you very much, Alex. And now we'll go to Bernie Farber.
Thank you very much, Tim. I became involved in this issue almost 15 years ago when I was the CEO of Canadian Jewish Congress. And at that time, I just literally took the word of the French government and of course saw an extradition hearing take place. And as CEO of Canadian Jewish Congress, I was one of the actual supporters of extraditing Mr. Diab to Paris. And for the last 15 years, at least for the last 12 years, since I started actually looking at this issue, speaking with lawyers, understanding what was going on, I've come to regret this. This has not been justice, and I have regretted the role that I have played in this. And so I have been doing whatever I can to make good. In my tradition, saying sorry is just not good enough. You have to show that you're sorry. And so I've written about this, have pleaded about this. It appears to me, and I'm not a lawyer, and maybe that's a good thing in this situation, because it appears to me in just a straight read of all of the evidence, especially of the evidence of the lower courts of the 2 French investigators that basically went to the French High Court and told them there is no case here. I thought, okay, this is it. Finally, Hassan Diab can come home and breathe a sigh of relief. Instead, it started all over again with a higher court somehow determining that what their lower court investigators, bear this in mind, again, coming from a non-trained legal mind, but somebody who has at least reading the material and understanding that the two investigators in France actually traveled, read the documents, and came up with a decision that in fact there is no evidence here. And so for the last number of years, 15 years and more, an innocent man has been literally dragged through the mud. In our tradition, we have a saying, in a way, Alex kind of alluded to it when he talked about justice. We have a saying, tzedek, tzedek tirdof. Justice, justice shall you seek. And our learned elders have always said, well, why is the term justice actually repeated in this saying? Tzedek, tzedek tirdof. Justice, justice shall you seek. It is repeated because we understand the importance of justice. We understand what can happen if there is injustice. And it affects, by the way, not only the one victim, it affects the family, it affects the friends. And in cases like this, I believe it affects an entire nation. We are all stained when injustices like this happen. I was more than pleased, overjoyed, as a matter of fact, when Prime Minister Trudeau said at the return of Hassan Diab that what happened to Mr. Diab should never happen again and should never happen to anyone. This, to me, was a clear and concise message to the Canadian people. Now is the time, Mr. Prime Minister, to put those words into action. We're all waiting, all of us here. We all come from different backgrounds. Sometimes we disagree on many things, but on this, we agree. Tzedek, tzedek, tirdof. Justice, justice must we all seek. Thank you.
Thank you very much, Bernie. And now we'll go to Rob Currie.
Thank you, Tim. I can only echo the submissions made by the preceding speakers, particularly Dr. Diab himself, about this absolutely unfathomable and unconscionable case. I think I speak along with so many voices where I say it has been all along within the power of the Prime Minister and the Justice Minister to put a stop to this farce. And I am mystified and disappointed at their refusal to do so. I think we can say to lift things to the international point of view, Dr. Diab, it appears, has been sacrificed on the altar of diplomatic coddling of France. Here on the very questionable rationale that they are a good and effective partner in international cooperation in criminal matters. I think Dr. Diab's case is sufficient evidence that they are not, and that has also been shown across a number of other vectors, particularly the refusal by France to extradite Father Johann Revoir to Canada. Father Revoir, as is well known, is credibly accused of abusing Indigenous children in Canada's north historically, and France has been uncooperative and obstructive in that case. But pulling back from the international, looking at the domestic, I don't think there's any doubt that the problems can largely be laid at the foot of Canada's extradition laws and practices. And my colleagues here today and other colleagues around the country have been united in calling for reform of those laws and policies and practices for some time. It has been known for a long time that our extradition laws are unfair, that they don't work properly, that they produce injustices. The Supreme Court tried to bring that to a more sensible place in its 2006 decision in the Ferris case. Regrettably, the Ferris was left unfulfilled. And we're now in a place where there is no room left for going to court and trying to interpret, trying to argue around Canada's extradition laws. It is clear that parliamentary intervention and reform are required. And on that point, if there can be said to be a bright spot in this swamp of injustice, it is that just earlier this year, a unanimous committee, the House of Commons Standing Committee on Justice and Human Rights, has recommended reform of Canada's extradition laws. That recommendation has gone to the Office of the Minister of Justice. And there are 20 recommendations in their report, and I would commend that report to the reading of everyone attending today. And I don't think we can capture it any better than recommendation number 20, which says the committee recommends that the Government of Canada undertake comprehensive reform of the Extradition Act as soon as possible and consider making changes to the extradition process not requiring legislation in the interim in order to avoid further injustices in extradition proceedings. So that recommendation, along with the 19 others in the report, are out there. Again, it's been on the Justice Minister's desk for some time. The Minister is required to respond. It's disappointing that Minister Lametti did not respond prior to leaving his post, but we will certainly be looking to the incoming Justice Minister to take this very pressing public policy matter seriously, because it's not just a case of abstract injustice. Dr. Diab is with us today. This is a case of wrongful extradition and now wrongful conviction by a foreign partner state that is very suspect in terms of the fairness of its legal process and aided and abetted at every step by Canada. It is truly, truly time to bring this to an end. Hassan Diab's face is the face of a victim of injustice, tarnishes Canada's legacy in this space, and it is really time to fix it. Thank you.
Thank you very much, Rob. We're now going to go to the question period. Journalists can signal that they'd like to ask a question either by raising their hand in Zoom or putting a question in the chat, and we will read it out or go to you. We'd ask that people keep their questions short, and you can ask one question and a follow-up question. Et vous pouvez aussi poser vos questions en français. So with that, are there any questions from the media? Okay. We're not seeing any questions at this time. Oh, here we go.
Like, if nobody else is going to ask, I'm just going to ask.
Yeah.
Dr. Diab's return to Canada, what has correspondence with the Canadian Justice Department been like, if anything? I mean, of course, we're aware that there was that trial conducted in absentia. At that time, was there any communication between Dr. Diab and any representatives from the French or Canadian governments?
No. Should I go ahead?
Hassan, yes, if yeah, you can answer that.
Yeah, actually, before the time of the trial, I contacted Canadian people in the embassy in France, and I asked them to attend the court if possible. And after a very long time, they answered right before the trial. They said, "Oh, we cannot help Canadians who are not there in France. So they want me to be there to help me." And that was the only communication with the Canadian government. They couldn't, attend the court, though they did it before during the bail hearings, but not during this trial. Just I wanted somebody to witness what was going on in the court, because I expected, certain things, but I didn't expect it to that extent of really absurdity in the court. They used every single little, I wouldn't say not smart thing, including to make my presence in Belgium. They made me somebody said, I swam from Lebanon to Belgium. And this is how they made the case for me being in Belgium, because I was able to swim 7,000 kilometers. And that was, it's in the decision. I was in Belgium, but they didn't say, based on the swimming course. I swam from Cyprus to Greece. I swam, I don't know, they made all these things, and they based the what's called evidence based on these little crazy things like this. But anyway, the government didn't reply. Nobody, answered from the embassy, and we are still till now in this situation of, I call it limbo.
Thank you, Hassan. Would anyone else like to add anything? No. Okay. Is there a follow-up?
Tim, if I can just make one more comment, which I forgot, and I really did want to make this point. Alex and others made this point as well. The bombing of the Copernicus synagogue was a terrorist act. It was a hugely disturbing, sad event that took the lives of many people. So let's not lose sight of the victims. We certainly want to lose sight of the victims. At the same time, of course, let us not make Hassan Diab yet another kind of a victim. But I just want to be sure that we understand that the Copernicus bombing was a horrible tragedy that should always also remain on the top of our minds.
Thank you, Bernie. Any follow-up question, Mr. Lee?
Yeah, sure. If nobody else is going to go up, can we just get a sense of the exculpatory evidence that's being ignored by the French courts? Because before coming into this news conference, of course, I tried to do some research, by which I mean light Googling, and it's not precisely clear what evidence is present that places Dr. Diab in Lebanon rather than in France at the time of this terrible attack, and what evidence is being ignored by the French courts. If anyone could provide some clarity or maybe a brief overview of what is not being looked at here.
Thank you. Maybe I'll ask if either Roger or Hassan would be able to speak to that.
Yeah, if you want to go ahead, Roger, you can go.
Yeah.
You have more stories, maybe.
Yeah, okay. What the two investigative judges found, and one of the strong reasons for their decision in 2018 to say that there was insufficient evidence to justify a trial, and released Hassan unconditionally and allowed him, of course, to return to Canada. One of the main things was the information that the investigative judges had gathered in Lebanon itself. This was not just a casual investigation. It involved interviews with some of the students who were there at the same time as Hassan in 1980. These were not friends, these were contemporaries. Some of them, most of them, hadn't heard or seen Hassan since that time. They confirmed that Hassan was writing his exams in October, the end of September, early October of 1980. That was a strong indication, but communication was also made with the university, Beirut University, and they also confirmed that Hassan was there, that he wrote his exams at that time. There was some confusion because, of course, Lebanon was in a state of civil war. The exams in that particular year had been moved from the spring to the fall, but that was confirmed also by the university. Hassan took those exams. They lasted for, I think, up to 2 weeks at least, and then required registration for the next semester. So all of that was there, and that is included in the report from the two investigative judges, Herbeau and Foltze. And I would add that these are not just sort of casual investigative judges. In the French legal system, the juges d'instruction have an enormous responsibility. They are required, indeed, to decide whether or not a case is sufficient to bring it to court. So, and both of them, Erbo and Folse, both of them have many, many years, I would say, at a rough estimate, at least 40 years experience between them. So it has to be taken a lot more seriously. The two judges, incidentally, appeared at the trial in April of this year and repeated, in fact, said before the court that they stood by their findings. So that was one. A lot has been talked about regarding the fingerprints on the famous hotel registration card. And that was seen initially as an indicator that this would identify the bomber and that it would be absolutely sufficient to convict. First of all, the French said that there were no fingerprints on the card that could be used. It later turned out that, in fact, there were some fingerprints on the card. However, when they were compared to Hassan's much later, by the RCMP, they were not Hassan's at all. Somebody else had obviously handled the card, but it was not Hassan. It may well have been the actual bomber, but they were not those of Hassan. So forensic evidence, alibi evidence, the story goes on. There were other things as well, but those are probably the two most telling. I won't go into the details of the unfairness of the trial itself, but this is a rather crucial point because a lot of people hesitate to say, well, the French, they've been supporting a good justice system for ever since 1789, and so they can't do any wrong. We all know that every country, including Canada, can make mistakes and does make mistakes, but that in itself is not enough. In this case, just to mention very, very quickly, an in absentia trial with this consequence in itself indicates unfairness. The fact that an in absentia trial has no provision for any appeal subsequent to conviction, that also is an important factor. The fact that unsourced and unknown intelligence information was reintroduced in the process, would not be allowed in a Canadian court, but was allowed in the trial in April of this year. So, and there's more, but just to be very clear, that the trial was an unfair trial. And from there, we can then go back and look at the impact on Hassan and the failure of the Canadian government to take this in a way that will respond to this miscarriage, will allow Hassan to return, I was going to say, to a normal life. But even if there's no extradition, even if Trudeau says we will not extradite again, it doesn't end there. Hassan has already talked quite clearly about the impact on his children, and that goes on, irrespective. So there's a lot of work still to do. But I hope that at least begins to answer some of that question that you asked. A very good question, important question. Thank you.
If you allow me to add a little bit to what Roger just said about you know, the exculpatory evidence and so on. And the irony is that I was extradited to France based on one element, which is the handwriting analysis. The irony is that the French court, with all its problems, they dismissed the handwriting thing that I was extradited on based on that, you know, bogus handwriting analysis. And now there's nothing left for France. So instead of having new evidence after the decision of the two investigative judges in 2018, they have less than before. And I could add also to the fingerprints France said they didn't have exploitable fingerprints when they submitted the record of the case in 2008. This is exactly at this, and they certified the record of the case on December 2008. This is the time when the French investigative judge at that time, before Herbeau and Fulzer, Mr. Trevidick, he had on his desk, he ordered himself, he asked the experts to conduct an fingerprint analysis on the hotel card. And the report came on November 19th, 2008. November 19th, and he certified the record of the case in December, a month later. He said there were no exploitable fingerprints, which is not true. I don't want to call it lie or anything, but you can imagine. That's what he told Canada. That's what he told the court. And everybody believed, because there is a presumption of everything is correct, whatever the requesting state is saying is true. And they took it from there. And I was extradited based on those things. And there was another fingerprint somewhere else on the police document. And they came to the court to say, well, they didn't match Diab's fingerprints, simply because in those days in France, you know, that's the first time I hear it from a police officer in the court. He said, in those days, we did not allow suspects to touch the paper they sign. So you sign in the air, practically. That's why they wanted to justify the absence of my fingerprints, because simply they did not allow me to touch the paper I signed. And stories like this go on, and tons of exculpatory evidence, like just they threw them under the rug and brought any other story like swimming to Cyprus, swimming to Europe, and they became the new evidence. Thank you.
I'd like to add, and I apologize for coming back to this question of the unfairness of the trial, but I wanted to mention something that is relevant to journalists, because I think that this is another illustration of what was allowed during the 3 weeks. At least 2 journalists were called as so-called witnesses, in quotation marks. They were not present at the bombing on Rue Copernic, yet their testimony was accepted by the court somehow or other as being the truth. I should add that many of the families of the victims rightly were given the chance to talk, but none of them was an eyewitness of the bomber himself. And so all of that, it amounted to probably at least 50% of the testimony was a witness impact statement, and it had nothing to do with the trial of Hassan. Thanks.
Tim, can I jump in there for a moment?
Yeah, go ahead, Rob.
I just want to build, I'm hoping this might be useful to the listeners. I want to build slightly on what Hassan and Roger said. There, in some of the pushback in the public commentary around this case, people have adopted this narrative, and we sometimes see this condescending narrative coming from the government and the government of Canada, and sadly from our courts as well, and the story goes, you don't understand, France has a different kind of criminal justice system than we do. And, you know, things look unfair to you because you're unfamiliar with the way the French criminal justice system works. And in fact, as Hassan pointed out, a lot of our extradition law is built on this idea that our government, in concluding an extradition treaty with another country, satisfies itself that that place is a good place, that it has fair trial standards that are recognizable internationally, and that it's okay to extradite Canadians there. So I feel the need to push back against that particular narrative. Sadly, we saw it from the Ontario Court of Appeal in Hassan's case. They trotted this thing out again. So in case there's any doubt, everyone here understands the basics of the French criminal justice system. We understand that it's different, that it operates differently. And the important key observation is the one Roger made. Any legal system can make a mistake. And here we see mistake upon mistake in a highly charged, highly politicized atmosphere. So no one is suggesting that France is a failed state or anything like that. What we're saying, though, is that there are clear problems with the administration of justice that have emerged in this case. On the one hand, you have very well experienced juge d'instruction who eventually said, wow, there isn't a case here. We better release this guy. And then we see very politically charged dynamics come forward to move the case along, which produce an unfair trial, closing the story on the unfair extradition that began it. So I just really feel the need to lay that out there. The problems in this case are identifiable. And if anyone wants to go looking for more evidence that France has got trouble with its criminal justice system, there are very credible human rights organizations out there who have written them up. And I would commend those to your reading as well.
And if I could just build on this as well, because I think this is a really important point. Perhaps we need look nowhere else to dispel this argument that that we in Canada are ill-informed and don't understand how justice is delivered in the French system, than the fact that those two juges d'instruction, who more than anyone have been through all of the details of this case, have done so from the perspective of the French legal system, its norms, its standards, its practices, its expectations, have done so over several years, came to their conclusion that there is nothing here, and not only nothing to justify a conviction, nothing to even justify taking the case to trial in itself, and then took the exceptional step of being willing to show up as witnesses to testify to that exact position when the trial did go ahead. I think we need look nowhere else other than that evidence, those findings from those two incredibly well-placed and well-informed, undeniable experts in all aspects of the French legal system.
Thank you, Alex. Are there any further questions for the speakers? Est-ce qu'il y a d'autres questions pour nos invités?
I'll actually ask a question. Can you hear me?
Yeah, go ahead.
Perfect. Now that the screen looks different, I'm just wondering if you can just tell me your message for the Prime Minister. If you could tell him something, what do you want him to know, and what specifically do you want the government here to do? If you could just answer that, that'd be great.
For that, I think I'll pass it over to Hassan.
Oh, thank you. I will reiterate what I said earlier, that nothing more than honoring and translating his words into action. When you say, like, I feel for Dr. Diab and his family.
Hassan, I'm sorry, but at least I am having trouble hearing you.
Can you hear me now better?
Much better.
Oh, okay. I will repeat again. It's a simple thing to honor his words of June 2018, that what happened to me shouldn't have happened and it should never happen again. That's so simple. And this is a chance for the new Minister of Justice to put this statement in action. Nothing more, nothing less. And I'm happy or somehow to see there's some hope coming from the reform front of the extradition law. I hope this will happen soon. They will implement this the 20 recommendations soon, but just honoring his words. That's what our message.
Thank you, Mr. Diab. I'm just also wondering if we can confirm, has France officially made this extradition request to the United States, and are you aware whether these proceedings have gotten started?
To Canada, you mean?
Yeah.
Yeah, we have no idea, actually. That's the limbo situation we live in.
And I think that's just one more example of the many layers of unfairness and injustice. The fact that Dr. Diab doesn't know the answer to that fundamental question, and in Canadian law has no right to know. And as a matter of Canadian law, wouldn't necessarily be informed essentially unless and until it's too late, which would be the point at which, once again, a formal extradition hearing is going to be held, and he finds himself trapped in this labyrinth once more. It's quite frankly outrageous, especially given the very unique and particular nature of Dr. Diab's case, the fact that this is his second time through the extradition process, the fact that he has shown at all stages to this point in time that he is cooperative, that he follows the process, that he shows up for every stage, the fact that he's being kept in the dark, and maybe kept in the dark for 24 hours, for 3 months, for 3 years, forever, as to whether extradition is underway again, is just not okay.
And can I add there as well, that when this question is asked of the federal government, of the Department of Justice, when someone says, has there an extradition request been made? The answer is always, that is confidential diplomatic correspondence, which we are not allowed to reveal. That's all. As Alex said, Dr. Diab has no right under Canadian law, and that is the law. It's the privilege around diplomatic correspondence, except that we know from the Revoir case that that confidentiality is subject to waiver by the justice minister when the minister chooses to do so, because it would take only that bit of light Googling to find out that when the Johann Revoir case was in the media and there was a lot of pressure being applied to the government about it, Justice Minister Lametti publicly announced that Canada had made an extradition request of France. So it is a law clearly that is subject to exceptions. If there were ever a case where a person should be informed as to whether an extradition request had been made, it is this one. And that is yet another example of the government's unconscionable attitude and practice in this case.
I'd like to add to what Rob just said. We should make no mistake that this is not just Hassan's case. This is something that can impact and does impact many Canadians. The hearings that were held by the Standing Committee on Justice and Human Rights, which lasted for 3 weeks, as I mentioned earlier, there was very powerful testimony, much of it related to Hassan's case, but it was also clear that there are many other cases that are decided quickly or because of political considerations, or where the extradition process is faulty and allows for quick decisions that are not available for cross-examination in the case of secret intelligence and so on. But that is also what we're asking. Clearly, justice for Hassan is the principle and the immediate demand, and that has to happen. That's why 10,000 people are on the petition that is going to be presented to the Prime Minister later today. But to think that this is just about one person and not about a broken extradition system in Canada would also be a mistake. And the other is the thing that I mentioned earlier, that the impact of this, irrespective of Trudeau's doing the right thing, is not quickly over. When a no-fly list continues to exist against Hassan, when that no-fly list can impact his children. His daughter, who was recently told that she could not travel to the United States to play in a soccer game because she's the daughter of Hassan Diab. So those things need to be addressed. And I won't even discuss the financial impact and cost to the family as well. This is no small matter, but that also will continue. Thank you.
Thank you, everyone. We have time for one final question, if there are any more questions. On attend pour une autre question, s'il y a d'autres questions. Okay. Well, I'd like to thank everyone for joining us today. I'd like to thank all our speakers, and especially Dr. Hassan Diab for being here today and sharing so powerfully what he's been through. And we'd like to remind journalists that there will be a rally at noon today at the Prime Minister's office at 80 Wellington Street, where they will be delivering a petition with 10,000 signatures in support of Hassan Diab and calling for no new extradition and to an end to this miscarriage of justice. So we'd invite you to also attend that. And there will be opportunities for interviews and to record the event as well. With that, thank you, everybody, and we'll end today's press conference.